Please welcome Attorney General Kris Kobach.
Bless you. Thank you so much. Oh, thank you. Please sit down. Please sit down. Now you've raised expectations by standing. So it is such a pleasure to be back here in front of the Wichita Pachyderm Club. I was just trying to remember. I think the last time I spoke here was in the election. Wasn't that right? I don't think I've been here since October 22nd. There you go. October of 2022. Right, exactly. It is, so anyway, it's great to be here now as your Attorney General. It is a huge honor, and I want to say thank you for getting me to this position. And I'm not just saying that, in a flip way, like he always says thank you. No, I'm saying thank you to you guys for helping me win Sedgwick County. Sedgwick County is something special. Shawnee County, Republicans statewide, Republicans haven't won Shawnee County in, well, as long as I've been alive, so over 50 years. Johnson County used to be winnable 20 years ago, but now, Johnson County goes for Obama, goes for Biden. Statewide Republicans don't win Johnson County. But Sedgwick County is winnable. It's a bigger county than Shawnee County population-wise. And yet, not only can Republicans win it, I was blessed to win it in 2022. I think that was what helped carry me over the top. And so it's just, there's something special about Sedgwick County as an urban county of this size that Republicans can win. And you guys are at the core of it as the conservative movement within Sedgwick County. So I just want to say thank you for helping me get here. It's such a great blessing to be in this job. I've really enjoyed it, and it's I feel like it's something I'm meant to be in. So anyway, I want to begin, but I want to talk a little bit about what it's been like as Attorney General, and then of course I'll take all of your questions and we can have a longer discussion. But many of you know that I had a career in law before I became your Secretary of State, and then subsequently went back to practice law for 4 years, and then became your Attorney General. But when I studied to become a lawyer, and when I was a law professor, and in my practice of law over the years, I always assumed that being a lawyer would be trying to figure out interpret what a contract meant, trying to argue how far a person's property rights go, or the more interesting cases, filling in the meaning of what the freedom of speech means, what the free exercise of religion means. These interesting debates about interesting legal questions. And that is what I thought I would be doing as an attorney, and that's what I also thought I would be doing as the Chief Attorney representing the state of Kansas and representing you in so many of these fights. Indeed, some of you may recall that my campaign signs in 2022 had 3 words at the bottom: sue Joe Biden, right? And I thought that those lawsuits would be about the extent of federal power and the boundaries of federal statutory terms, where they were trying to stretch the terms of the law. And, lawyer stuff, interesting interpretation of words and contracts and rights and things like that. But I did not anticipate that I would be fighting in court for something that we normally take for granted: truth. Now, there are disputes about facts. Almost every case has disputed facts, but there is an acceptance of the fact that there is one set of facts that is correct, and there are certain fundamental truths that are undeniably true. It is undeniably true that the sun, the rotation of the earth will cause the sun to appear to rise in the east every day. It is undeniably true that gravity keeps us fastened to the floor here and to the certain things that are just you can't argue about. But there is something deeply troubling going on in the law today, and it's evident in the state of Kansas. It's evident in other states as well. But I have seen it not once, but I've seen it in 5 different instances where I'm actually in court or about to go to court defending what is true and arguing that something is true that everybody thought up until 5 minutes ago was obviously true. And it's a bizarre world we're in the practice of law. And I'm going to give you 5 examples of this and talk a little bit about them. Now, actually a couple of them are about the trans movement. And the first example of this is the embrace of the lie, and I don't think anyone can seriously argue this point, the lie that men do not have an advantage in sports over women, or in athletic endeavors over women. That used to be a universally accepted truth. And we're going to be arguing in a case that Kansas will be bringing here in District Court in Kansas, the state of Kansas will be bringing against the Biden administration's forthcoming rule interpreting Title IX. And in this forthcoming rule, they're going to basically be saying that states that have said girls' sports are for girls, biological females, and boys' sports are for biological males, that those states are not actually defending fairness in sports. Fairness is one of the things that might be involved there, but that's not necessarily necessary. It's not necessary to segregate sports according to sex for the sports to be fair. That is the position of the Biden administration in court. It is not necessary to do that for the sport to be fair. Well, you all know, I don't think I'll have to persuade you too hard of the truth here. I mean, we all know that when you see Leah Thomas towering over the other swimmers in the collegiate national championship, he's 6'4", and his competitors were like, 5'10" or something like that he had certain advantages, and that his growing up and experiencing puberty as a male gave him certain advantages in his skeletal and muscular structure. This is the truth. But the U.S. government, the Department of Justice, which used to be the most respected group of lawyers in this country, are taking the position that that's not necessarily true. It might not be true. Donna was just mentioning my 5 daughters. Many of you know Reagan, and she's been to this event before, although I think it's been a couple years. Reagan is now about to turn 18. She's in her senior year in a homeschooling group, but she's on a team, a cross-country team of homeschoolers in our area, and it's actually a really big team. And she just ran in a race on Tuesday, and out of 40 runners, she got second place, and she's going to be in the state championships this coming tomorrow, actually, Saturday in Manhattan. And she's doing really well. Like, I don't know how she's doing really well, because I am not a runner, and you can see that it's way too big. If you're over $2.25, you're not a runner. And my wife Heather is not a runner, but Reagan somehow got blessed with these running genes, and she's really, really fast. So fast that several D2 colleges have been sending her letters offering scholarships. And, Dad really loves to hear that. And actually, one of the places she's considering is Wichita State. That's on her final 5 list, I guess. So she's Wichita State's seriously in the running. McPherson is actually seriously in the running, too. So anyway, the point being, she's getting scholarships because of her prowess in running cross country. If biological males were competing in that event, she would have no prayer of even thinking about a scholarship, or even thinking of finishing in the top 10 or even in the top half. She's really good, and she's a lot faster than me. But when you go to these cross-country meets, there are dozens and dozens of boys who finish before the first place finisher in girls. And that's just a fact of biology. But that fact is something we are being told we cannot actually say is a fact anymore. And it is just astonishing that in court we are having to actually argue things that used to be undeniably true. The second example is also in the trans sphere, and this is a case that I have been arguing. You've probably have read about it, and I've been arguing it personally in a state district court in Shawnee County, and that is our driver's licenses and birth certificates shall reflect biological truth. The legislature, including the representatives here present, voted overwhelmingly for SB 180 in this past legislative session. And as you probably know, the governor vetoed SB 180. And then the legislators came back and with exactly the number of votes needed. It might have been one to spare. Anyway, we had just enough votes to override the governor's veto. And SB 180 says, yes, give yourselves an applause. SB 180 says something that, again, should be uncontroversial, and it was uncontroversial until 5 minutes ago, and that is that that our birth certificates should reflect biological sex at birth, birth certificate, and that our driver's licenses should reflect biological sex at birth. Well, my office issued an Attorney General opinion at the end of June. We did this anticipating that the governor might. We weren't sure if the governor was going to obey the law, but we anticipated that she might have her administration not obey the law. So we issued the opinion, and we made sure we got it done quickly at the request of a legislator before July 1st, when the law took effect. And as you know the story, the governor announced a few days later that no, she did not interpret the law the same way, even though the law is written extremely clearly, and any person familiar with the English language and the basic construction of sentences would read the law as saying what the law said and saying what the legislators thought they were passing. Anyway, she didn't, and so we had to sue the governor. And a few weeks later, toward the end of July, we were able to get a restraining order against the governor requiring her to follow the law. Now that case is not over, though, because the ACLU has jumped in, has sought to intervene in the case, and so they're going to argue that, well, whatever the law says, if it does say what you Republicans say it says and what the English language says it says, it's unconstitutional. So they're going to be making some rather ridiculous arguments about freedom of expression and the First Amendment, that somehow it's a violation of your First Amendment rights. And that brings me to my third point, and this is the last one on the trans subject matter, and that is that not only must you embrace certain things that are not fact, like the historical fact of someone's. We are all part of history, right? Each of us is part of a historical event. On a certain date, each of us was born, and at that moment, the doctor ascertained, based on the baby that he had just delivered, that you were either male or female. And it was recorded in a certificate, a certification of fact, that you were a certain weight, that you were a certain sex, that you were born to a certain mother. This is all a statement of historical facts. But now, in this court case that we are arguing, they are claiming that we must change these historical facts, and the birth certificate must say something else. Not that when I was born, a male was born, but that if I decide so, I can have it changed to say that a female was born. That is not historical fact. And you can't even say that the baby at that time was a female trapped inside of a male's body, because you couldn't even know if the newborn baby really was feeling kind of female when he was born a male. It's just absurd. But they want us to change historical facts to embrace the lie that the baby male was actually a female. And there's no disputing that. That is just, it's a fact. Now, they're absolutely, the trans movement, people are free to express themselves and call themselves what they want and dress any way they want. We are a society that gives the individual great freedom. But that doesn't give the person the freedom to change facts and to change historical reality. But that's what they're asking us to do. Similarly with the driver's license is a state document created by the state for state purposes. It's not your little canvas on which you can paint your aspirations and your thoughts and your ideals and then present this canvas to others. No, actually most people don't present their driver's license to everybody they meet. They try to keep the information on their driver's license rather discreetly hidden unless they have to present their driver's license number. But we are being told that the driver's license is in fact a document that shows personal aspirations, not something that just reflects biological fact. And then here's where it gets even weirder. You may have heard this in the news this past week. So I sent a letter to the Chief Judge of the 10th Circuit of the U.S. Court of Appeals. That's the circuit that Kansas is part of. Letting the Chief Judge know that there are certain district courts, fortunately none of them are in Kansas, but there are certain district courts in our circuit where the district judge, the federal district judge, is requiring attorneys, those of us writing briefs and making arguments in court, to address other attorneys and parties and witnesses by their preferred pronouns. Now, we have been taught in law school and as attorneys and in our ethical tests that you must always tell the truth. You must always represent the truth in every brief, everything you file to the court. You can be sanctioned by the bar for making a mistake and saying, or intentionally saying that something that is not true. But now we are being told, as attorneys, we have to state something that is not true. And this is particularly problematic when it comes to clarity in briefs. Now, in a courtroom, I might be able to say, the witness here, and just identify the witness, just say the witness, or I could say opposing counsel and gesture to whom I'm referring to, right? But in a brief, if you start saying they, when you're referring to a particular plaintiff, they think this, but it's actually one person, then the whole English language just becomes a mess. And the clarity that we are, by ethical obligation, supposed to achieve in our writings and in our statements to the court suddenly goes out the door. So this notion that you have to embrace something that is counterfactual, and then you have to, and you as an attorney can be punished if you don't embrace the lie of whether it's two people or one people, they, he, is just bizarre. But that's where we are in the courts today. Okay, so let me go to another example. Fourth example. This is outside of the context of the trans movement. And this is the abortion movement's efforts to suppress truth. So in 1997, the Kansas legislature passed the Women's Right to Know Act. The Right to Know Act simply required that a woman seeking an abortion be told certain true things before she go through with the procedure to terminate the life of the unborn baby inside of her. That she simply be exposed to some true things, including information on fetal development, some basic facts about fetal development, clear, undisputed facts about fetal development, a list of risks that may be involved in some abortions. Not always, but just risks that are there. Just like when you see those wonderful commercials for all the different drugs today, and then at the end, the fast voice says, and this may cause bleeding, diarrhea, blah, blah, blah. That is simply acknowledging the risks, right? And so this is telling the woman about to seek an abortion that there are certain risks. In addition, a list of organizations that truly do exist to help a woman if she decides to continue with the pregnancy. So organizations that are out there. These are just facts. Well, that was amended over the years as ultrasounds became better and more available and more widespread. It was included, one of the things that is offered is the woman may see an ultrasound image of the baby in development as more truth, a true image of reality. And then this last session in 2023, the legislature added one more factual statement to the things that must be presented to the woman. And this was the factual statement that in some cases, the abortion pill procedure can be reversed before the second pill is taken. That is truth too. It is not true that in all cases it may be reversed, but it is undeniably true that in some cases it can be reversed. There's no disputing that. But now the abortion industry has decided to take on not just the 2023 edition, but the whole thing. This true information should not be presented to the woman before she decides to go through with the abortion. Now just think about this. In almost every situation where you are about to undertake something serious, you are supposed to have consent, and it's supposed to be informed consent. But here where you're about to terminate a life, the pro-abortion left is saying, no, you shouldn't be exposed to that information. The truth, be it true or not, well, first they'll contend it's not true, but that's obviously a lie. But then they'll say, no, that truth is something you shouldn't be exposed to. Why? Because you might make the wrong decision. What makes it wrong? Because it's the decision they don't want you to make. And again, it's an assault on truth, facts. No one should ever have an objection to a law requiring certain facts to be presented before someone makes an important decision. When you sign up for a bank account, they've got to disclose certain facts. When you sign up with a stockbroker, he's got to disclose certain facts. These are just things you should know before you go through with the decision. But on abortion, no. That's not that important as a decision where we have to put certain facts. So again, as a lawyer, I'm just blown away by this because this should be something that the other side would say, there's this, yeah, we have to agree on that one. This is just presenting certain facts. And so now I want to go to number 5. This one is another. Again, it's an assault on truth in a different context. Now, many of you know that I've been involved in the immigration issue for much of my career, and actually started when I was working for John Ashcroft at the U.S. Department of Justice. And in 2000, now jump forward to 2009. In 2009, you may recall that there was a joint session of Congress, and that President Obama addressed this joint session of Congress about Obamacare. And you may recall, if you were watching it or if you heard about it, that there was a certain congressman from South Carolina who stood up and shouted 2 words in the middle of that speech. Anyone remember what those words were? You lie. You lie. You all remember what those words were. Yeah, Joe Wilson. Joe Wilson shouted, "You lie!" And what was he accusing? Doing something that extreme? Standing up, interrupting the president's speech about? It was the claim that Obamacare would not be given to illegal aliens. And he said, "You lie." And he was actually correct. At that time, the bill that was presently pending did not clarify that it would not be given to illegal aliens. And so because of the big brouhaha that Joe Wilson helped instigate, an amendment was added to the bill that said very clearly, aliens who are, for an alien to obtain Obamacare benefits, the alien must be lawfully present in the United States. And so that is part of the law, and it's right there in black and white. Well, fast forward to today, and or this year, in March, the Biden administration announced that they would be giving Obamacare to certain illegal aliens. Now, how can they do this? Well, they issued a proposed regulation. And in this proposed regulation, it actually says, for the purposes of receiving the benefits of the Affordable Care Act, aliens who fall into certain illegal categories will be deemed lawfully present in the United States. We're just going to deem someone who's unlawfully present to be lawfully present in the United States. Well, that's like saying, for the purposes of whatever, we'll be deeming someone who is biologically male to be biologically female. We'll be deeming day to be night. We'll be deeming you can't just deem something that is untrue to be true in the law, but that's what they're doing. Again, it's an assault on truth. There's no question that the individual that they want to give Obamacare to is illegally in the United States, but they don't care. They're just going to say, we will deem what is unlawful to be lawful. And there are a lot of things that this administration has done to stretch the law. Usually you stretch the meaning of a word. But this is the first one where they're simply saying, we deem the meaning of the word to be the opposite of what it is. It's just extraordinary, and that is an assault on truth. It's truly Orwellian, right? It's double plus ungood. It's the Ministry of Peace at work. And so anyway, this is where we are today with this administration, in courts across America, in Kansas with some of these cases we were fighting, where it's not just about arguing about what a law means or what this particular word means or how far does this right go. It's about arguing whether something is true or not. Now, why do they care about this Obamacare deal? The reason they care about it is there's always been an ebb and a flow in in illegal immigration and legal immigration into the United States. And illegal immigration, contrary to public misconception, people go both ways across the border, a lot. And they don't want people to go home. They've opened the doors so that we're seeing somewhere in the neighborhood of 2 million, we don't even know the number, 2 million illegal aliens coming in every year now under the Biden administration. But they would rather they not leave. They would rather they stay. And what better way to encourage them to stay than to give them a very valuable public benefit, free health care, which would not be available to them in the home country, would not be available anywhere else in the Western Hemisphere other than in Canada. That's what they're giving. It's the second half of the open border. Yes, the border is open, but the second part is the Biden administration wants illegal aliens to stay because they believe that eventually there will be an amnesty and eventually there will be some twisting of the law to give these individuals citizenship. And then after that, once they have citizenship, what can they do? Vote. Yep. And this is something that I used to suspect until in 2006. Barney Frank, representative from Massachusetts, you may remember him. Well, he lived up to his name and he was very frank, and he said in a public speech that yes, we must give these illegal aliens amnesty, and the reason we must do so, he was speaking to a union group, the reason we must do so is that they will vote in the interests of labor in America when they have their voting rights. And so although in the short run you guys may be upset because they're competing for your jobs, in the long run it'll be better off because the Democrats will have a stronger share of Congress and we will be able to pass pro-worker legislation. That is Barney Frank, 2006. And he let the secret out of the bag. Now Democrat leaders are talking about it all the time. We need this unstopped, unchecked immigration because we need to solidify our majorities in certain states. And of course, what they really want to do is turn Texas blue. But that's a depressing topic, so we won't go on that one. So at any rate, the unifying theme of all this is I'm in court arguing things that are just like pounding your head against the wall. You're arguing that what is true and what is not true, and that no one should be sheltered from the truth. But that's where we are. And so although it is troubling and it is in some ways disturbing, I do enjoy being in the fight. And I doubly enjoy being in the fight when what I'm fighting for is truth, not just a particular interpretation of the law. So I want to thank you for giving me the opportunity to be in the fight for you and be in the fight for the state of Kansas. Thank you very much. And I'd love to take your questions.
Hey, Chris, good to see you here today. Thank you for coming.
Thank you.
I've got kind of a twofold thing. In South Wichita, crime and mental thefts and homelessness go hand in hand, so it kind of runs together. Anyhow, a few years ago we passed a mental theft law. Most of it's never been instituted. And Derek Schmidt, your former guy before you and whatnot, said that only police officers could prosecute mental theft. So city and county says that they can't do anything. Their hands are tied. So we're just being overrun with, basically they can't do anything. It's not even being prosecuted and stuff like that. Can you get that overturned or change the law so that locals can prosecute mental thefts?
And you're saying mental theft, right? Yeah. No, it is a huge. It's a huge problem, particularly in Wichita. If you look at where it's happening in Kansas, for some reason, Wichita seems to be the concentration of where a lot of this theft of metal, valuable metals, sometimes just theft of metals you wouldn't think of as that valuable, whatever. There's a lot of theft. There is a statute in Kansas law that the Schmidt administration did interpret, and the statute does give the responsibility for prosecuting to the Attorney General. And I will say that we are actively engaged in prosecuting at a minimum one case in Wichita right now. It hasn't been filed yet, but we take it seriously and we are doing it. I don't have any objection to allowing county attorneys to bring prosecutions as well. That would normally be in the case of a crime. That would be the local official who would do it, or the Sedgwick County DA. It would take I'd have to review the opinion of Attorney General Schmidt, but I'm pretty sure it would take a constitutional amendment. A statutory amendment, and we wouldn't have any objection to that. So if legislators wanted to do that, they could absolutely do that, and you wouldn't hear an argument from me. I think one of the nice things about the way the law is structured in terms of crime in Kansas, criminal laws in Kansas, is that in most areas there is concurrent jurisdiction. The county has it, and the county can bring in the Attorney General if they wish, and that happens in really high-profile cases quite a lot, like homicides. There are other areas where it's shared, like in election law. Both the county attorney and the Attorney General and the Secretary of State have jurisdiction, and I think that's good because prosecutorial resources are limited. Sometimes there just aren't. Well, almost all the time there just aren't enough prosecutors. For those of you who know somebody in law school, encourage them to think about becoming a prosecutor, because I'll tell you, there's a huge demand all over America. There's a shortage of prosecutors right now. And so the more we can allow anyone who's got the resources to take the case, the better. So thanks for the question.
Hello, Chris.
Hey.
You're talking about your daughter, and the first time I saw a man standing next to a woman up on like a swimming event, first thing I thought, well, that's a crime. But my question to you, even if it was just a misdemeanor, it's a crime. And there's a lot of things, like you said, going on right now that's a crime. So my question to you is how did they preempt it before they committed the crime? How did they change the law before the guy got up on the podium next to the woman? How did they manipulate it?
Well, the interesting thing is we don't have law until recent years. We never had laws on this. The rules, not criminal law, but just rules for sports were set by the Kansas State High School Athletic Association in Kansas, or by the NCAA in national collegiate events, or by the other relevant, the NAIA, the various collegiate leagues set the rules. And you didn't need a statute, because why would you need a statute to say that, men should compete against men and women should compete against women? And so the way this happened is that this area where there is no formal law became an area where the rules were just changed by those who control the rules. And that's why the legislature had to undertake this extraordinary step of saying, in girls' sports in Kansas, and not just at high school, but also at university level, only biological females will be able to compete in those events. And you would think that this would just be something you would never have to say. You don't need to go to the law to codify what is a basic rule of fairness in sport. Nobody gets to take a jump start ahead of everybody else. These are just so obvious to the concepts of fairness. Wrestlers who weigh 100 pounds don't wrestle against wrestlers who weigh 190 pounds. I mean, it's just obvious. And so the law didn't need to come in. But now the law is being brought in, and of course the law can trump rules by various conferences and various associations of schools. So, good question.
Hi, Chris. I have a question. There was a speaker who talked to a school board, and he pointed out that some of the books in the libraries had graphic sexual content, and that the school board should consider whether they were liable for exposing children to pornographic materials. Is that something?
So, it's a legal theory, is what it is, and pornography. There's a famous quote from, I think it was Justice Powell, who said, "You can't define pornography, but I know it when I see it." Right? And so that's one of the issues that inevitably arises in attempting to apply a pornography statute to these books. And there have been all kinds of court decisions. And that's one of those interesting court decisions that I thought as a lawyer I might be involved in. They get to things like, well, a photograph is pornography, but a drawn image is not pornography. All these little distinctions in the law, right? And who knows what the right answer is. But the point is a good one, because there are many libraries in schools that do have material that if anyone in this room read the material, we would say, whoa, I don't want my kid reading that. Or if this is going to be something that is available to read, then I want to be informed, and there ought to be some parental notification if this is going to be placed on required reading in any class. And this is an area where as you know, the State Board of Education, some of the State Board of Education candidates have been talking about this and raising attention on this. You would think that in this era we could simply have those who are elected to represent the interests of parents, whether it be at the State Board of Education or in the school district, would be able to say, okay, this is what our decision is. But unfortunately, these issues all too often go to court, and people who want to present this material to kids will not relent and say, okay, yeah, you control the library, whatever you want. So we'll see. But the answer to your question is, could you? I guess where you're going with the question is, could you apply a pornography crime to it, and I guess the answer is the classic lawyer answer. It depends. You know, if the facts were all aligned in a certain direction, conceivably, but you know, frankly, our pornography laws were probably, most of them, whether they be local ordinances or state law, you know, are not drafted with that particular problem in mind. And so it's always better when the legislature comes in and says, okay, this is the issue, this is the crime. Now, of course, in that particular sphere, you've also got First Amendment questions. But when you're talking about exposing children to it, usually the First Amendment is a side issue. Yes, the person has the right to write and publish what they wish, but that doesn't mean that the school district must be forced to carry that material in the library, or that the teacher has a First Amendment right to force her students to read the material.
Yeah.
Mr. Kobach, thank you for coming here. You mentioned about medical care for illegal immigrants. The problem, practically speaking, if somebody comes to me, I'm a physician. If somebody comes to the gunshot wound, I cannot say, I cannot take care of you because you're illegal. Similarly, if somebody comes to me, the gunshot wound, bleeding from gunshot wound, I cannot say, go back, go home, I can't take care of you. I cannot do that. As a physician, we take a vote. That is, we do our best to save the life of the patient. When the patient is illegal or legal immigrant. So what do you think we should do in a case like that?
Well,
coming to bleeding or gunshot wound?
No, absolutely. Not only do you have an ethical obligation to care for the person, you also have a legal obligation. It's law. You have to provide care if you are an emergency room doctor, regardless of the person's ability to pay and regardless of the person's legal status. That has been federal law for a long time, and in many states there's also state laws reiterating that same thing. So yeah, you absolutely do. And that is one of the reasons why many of you know that our emergency rooms over the last decade have become more and more crowded, because awareness has gotten around that, hey, if you go to an emergency room, they can't turn you away. And so you see many people who are here in the country illegally who do not have an insurance policy. They could buy one. There's nothing prohibiting them from buying one while they're here. They go and get free medical care in the emergency room. And so the emergency room becomes crowded, especially in cities where there's a large population of illegal aliens. So, the answer to your question is absolutely. The emergency room must treat the person who is, facing an emergency medical situation, and it's right that our law requires that. But I think that's a very different question about that, rather than should a huge public insurance plan that tells you in advance you're going to get all kinds of coverage and this situation is going to be covered and it's for free because your income is below a certain level. That's different than saying in advance, we're going to give this to you regardless of the fact that you are in the United States illegally. And I think that ought to be a question on which everybody agrees. But unfortunately, the left and most of the Democrat Party, in fact, nowadays, virtually all of the Democrat Party think, no, we should be providing free medical care at our expense, at taxpayer expense, to those people who are in the country illegally. No disagreement on the emergency care, but the free insurance, that's a different issue.
Yeah.
Hi, thank you so much for being here. I'm a new county commissioner in Harvey County, just north of here. And I'm seeing some things come through that are very sneaky and they look good, but it seems to be a part of the federal land grant. I was wondering if you'd want to speak about the 30 by 30 land grant initiative.
Yeah. This is how many of you are familiar with 30 by 30? You've heard about it? It's this federal. It's very ill-defined at this point, but it's a federal statement of an objective by the Biden administration, or did Obama? I think it was Biden administration did it. That by the year 2030, they want 30% of America to be in some sort of conservation use, or be federal or state public land, or be in some way controlled for the benefit of the environment. And that's where, but they don't lay out specifics of how we're going to do this. But even as an objective, it's wrong, I think, because we are a country where private property is the norm. Now, Kansas, by the way, is on the extreme of the private property spectrum. Over 98% of all real property, all land in Kansas is privately owned land. We are not a state like Alaska, where the vast majority is publicly owned land, or most of the mountain states, where either a huge percentage or the majority of the land is publicly owned, be it federal or state. We are a state that treasures private property. So the idea that you could bring 30% of Kansas, now they don't say it's got to be 30% in every state, but the idea that you could bring a huge percentage of Kansas into this situation of control, and they don't, again, say what everything could be. Would you force landowners to enroll their land in the Conservation Reserve Program? That's a program that many landowners in Kansas do, and many hunters in Kansas love, because the farmer takes his land out of rotation and crops and puts in native wild grasses. It's great for game, great for habitat, but it's voluntary, right? And the farmer is paid per acre for putting his land in the Conservation Reserve Program, and he can take it out after 10 years or whatever the duration of the contract is. That's fine, and lots of farmers do it, and there are lots of good reasons why we all benefit from it, but it's voluntary. No one is forced to. Are they contemplating forcing Kansas farmers and ranchers to put their land in the CRP program? I hope not, because that would deeply infringe on their property rights. And so the devil, I guess, is in the details, and they haven't given us the details. But I don't see how they can possibly get to 30% without massively infringing on our property rights. And if they try, and I guess it's, the end of 2023, so they got 6 more years after January. If they try, I know one state that's going to be taking them to court. So don't worry about that.
In order to have a civil society is based on the concept of an implied social contract. And I would think that people who blur the lines of gender violate that social contract. And there's a basic element of honesty, integrity, forthrightness, that when people start. So do you see how the social contract that underlies everything we do could be at odds with, you can pick whatever gender you want to be, you can do whatever you want to do?
Maybe. I'd have to have you explain it to me more. So the social contract, I'll let you respond. So the social contract is this notion that if we were all like behind it's called the veil of ignorance. If we didn't know, we weren't born yet, but we were about to be born, and we were going to come into this society, what would we like the rules of society to be? You don't know who you are. You don't know if you're going to be rich or poor, short or tall, male or female. We would all agree that society would be better if, well, we'd have free speech, we'd have property rights, we'd have elected government, and that these are things that we would socially contract to, and then once we're born, we'd be like, oh, thank goodness we did that in this imaginary exercise. So I'm just puzzling with why would you could argue that the trans movement might argue, well, if you asked people in this veil of ignorance state, they might say, yeah, you get to choose which sex you are once you come in.
Also, is there a bumper sticker on the lectern up there?
Yes. Oh, I like that. I'm non-binary. I don't use computers. I love it. Is that yours? Thank you. Thank you. So I don't know. It's a very interesting question. I mean, this whole trans issue is so mind-bending. As a litigator, as a lawyer in court, the idea that we're doing these things it challenges the law in so many different ways. So anyway, good question.
Thanks for being here, Chris. I'm sure you're aware of the convention of states movement.
Yes.
Where it is in the state process now. My understanding there's going to be a lawsuit since it's passed the majority in both chambers. Do you know anything about that, or will you be involved in that?
So I am a proponent of the Convention of States. I think it's a great idea. It's something I've favored for a long time. Thank you. It's an issue on which Republicans, we have our disagreement. When she was alive, I was very close with Phyllis Schlafly, and was blessed to get to know her and do stuff and go to Republican national conventions and be on the platform committee with her and speak at her events for Eagle Forum. and got to know her pretty well over the last 15 years of her life. And this was one issue on which she was dead on the opposite side, dead set on the opposite side. She was absolutely against the Convention of States because she was afraid of a so-called runaway convention, which the Convention of 1787 was a runaway convention. They were only supposed to draft amendments to the Articles of Confederation. They were not supposed to draft a whole new constitution, et cetera, et cetera. So she thought that risk was too great. But I think most of us are probably on the Convention of States side today, and I think Mark Levin did a great job about a decade ago of laying out the arguments. But our Constitution today is a hollow shell of what it once was, and so hoping that we can restore it piece by piece through judicial decisions may be futile, and so perhaps we should have a drafting convention according to Article 5 of the Constitution to restore it and add clarity to those areas where the rules have been distorted. I mean, the best example of this, just now going off on a riff here, one of the reasons I think a Convention of States would be particularly useful is with respect to the commerce power. The commerce power of Article 1, Section 8 that says the federal government shall have the authority to regulate commerce between the states. Well, 90% of what Congress passes is passed as a so-called exercise of the commerce power. When they restrict gun rights or restrict ammo purchases or whatever, what are you doing? Oh, we're regulating commerce. When the federal U.S. Fish and Wildlife Service issues a regulation, requiring steel shot for waterfowl, oh, we're regulating commerce. When they do a federal emergency use authorization for the COVID vaccines, what are you doing? Oh, we're regulating commerce between the states. Everything under the sun. Oh, education, that's commerce between the states. Everything is just interstate commerce. And so that clause has gotten blown way out of proportion. The Founding Fathers never intended that. The ratifying convention notes never intended that. The Federalist Papers in Federalist 45, where Madison is defending how the states have all this power and Congress has these tiny, tiny set of powers. Clearly, he was not thinking that the commerce power means what judges have said it means over the past 85 years. So back to your point, a Convention of States would be really, really useful to say, no, Congress does not have the power to do this. Only the states can do this. Congress does not have the power to do that. It would be a very, very useful thing because it will take decades of court decisions, and it may never happen, to roll back the power of Congress to what the Founding Fathers intended it to be. So anyway, long answer to a short question. I do favor the Convention of States. There may be litigation in Kansas over this issue because without getting too much into the weeds, the question is whether a simple majority of the legislature can do it or a supermajority can do it. And that's been a stumbling block in Kansas. As the state's attorney, sometimes I have to be wherever we are. If somebody sues the state, then I have to defend the state's position. But I am hopeful that Kansas will one day be fully on board with the Convention of States.
Thank you for standing up for truth. The legislature, I believe the Republican side of the legislature believes in truth. I believe most of the people in this room believe in truth. And sometimes when we get into subjects that are touchy for ourselves, maybe we get a little iffy. But bottom line is, I believe we're fighting for the truth on SB 180. The other ones you mentioned this morning. I just want to thank Marvin Robinson, again, you guys have heard his name. Marvin Robinson, or the Democrat in Kansas City, who stood against the fight of the Democrats and took bullet after bullet, verbal bullet after bullet, and still does today from his party, because he stood for truth and said, it's obvious that a woman's a woman. It's obvious that men are stronger than women in sport. Those kind of things he went ahead and voted on because of the truth. I appreciate the fact that we have an Attorney General that also does that, and we'll try to continue to hold that same line, but also to thank the people that sometimes vote against what we say, but stand behind them when they do vote the truth. Thank you.
Thank you. I appreciate those words.
I want to go back to the land question on land purchased by foreigners that are non-citizens.
Oh, yeah.
Where are we at with that?
Yeah, so great question. So this is a bill that I proposed, and then several versions were introduced in the legislature in 2023 to say that foreign nationals and foreign-owned corporations cannot purchase agricultural land. So the way it ended up being drafted was land over 10 acres in the state of Kansas. And this law, or a version of it, is already in effect and has been in effect for years in Nebraska, in Iowa. Missouri adopted it more recently. And I thought it would be a slam dunk. It was part of my legislative package. I think I had 5 bills that I wanted to push for in January. And this was one of them. But we got 4 of them, and this is the one we didn't get yet. So the issue is still in front of the Kansas legislature. I recently testified, I think it was in September, in front of an interim committee that Senator Mike Thompson chaired, and he's going to be speaking before you guys. When was it? Next month? November. Okay. So yeah, this issue is very much alive, and there will be more consideration of the question. And there are many reasons why we should do this, and I want to tell you a little bit about why the bill didn't get passed. So again, you poll this issue among Kansans, and I would imagine everybody in this room would agree with that, or virtually everybody. If you poll ranchers and farmers, the people who own parcels of land greater than 10 acres, the reaction is overwhelmingly in favor of this bill. When this bill was, so why? Why do we believe that? Well, there are 2 big reasons. One is security, national security, and security of one's person. Of course, China has been, rapidly increasing its share of foreign-owned land. Now, the foreign country that owns the most land in the United States is Canada, for reasons that are kind of obvious. They've purchased a lot of land. Canadians have purchased a lot of land in the northern tier of states. But China is rapidly increasing its share. Now, it started very low, but it's going much higher. And you probably have heard of these, acquisition of land in North Dakota right next to an air base. The acquisition of Smithfield Foods, I think that's the one, in Iowa, controlling a ton of land, as well as a huge chunk of the pork producing industry or packing industry in the United States. And, it's a national security issue if they're trying to gain intelligence about a nearby air base. Or they're trying to gain access about our power supply, or if they're just trying to control the food supply. Because, during COVID in particular, when things started getting shut down and the supply of meat was decreasing because of restrictions on the plants operating, China wanted to ensure that their supply of pork would continue and their supply of other foods. The Chinese are very wealthy, but one thing they don't have is enough food to feed their entire country. They also don't have enough oil to power their entire country, and that's why they have such a cozy relationship with Iran right now. Well, anyway, so there's a national security question here, and that is we don't want China in particular, but there are other countries too. The Mexican drug cartels have been purchasing land, not just in Texas and California, but all over the United States. There are many stories about this. There are lots of other foreign entities that we would rather not purchase land in Kansas. And then there's the other internal reason, and that is if you look at polls of, the average age of the farmer in Kansas, I don't know, I read this article probably a couple years ago, and I think it was 65 or 68 or something like that, and now it's probably even older. Our current generation of farmers and ranchers is aging out, and it's not being handed down to their sons and daughters, as you might imagine, in the scale that you would imagine and expect. And the number one reason, according to polls done by various agricultural groups, the number one reason that they can't carry on the family tradition of ranching or farming is because land is too expensive. And so if land's too expensive, why in the world would we add to the competition for a parcel of land foreign nationals and foreign-owned corporations? So anyway, should be a slam dunk, right? Well, we get into the committee, and what's the organization or organizations that were most vocal in opposition to this? Kansas Livestock Association and the Kansas Farm Bureau. Yeah. And what's their argument? I'm like, what possibly could be the argument? You know me, I'm not going to pull punches. I'll tell you who said what. And I said, so what was their claim? Their argument was willing buyer, willing seller. That's the argument. I get it, but we put all kinds of restrictions on willing buyer, willing seller. We don't let the willing buyer of cigarettes who's 17 buy the cigarettes. We don't let all kinds of people who have certain legal impediments buy firearms. We don't, the willing buyer, willing seller claim, governments have put restrictions on that as long as there have been governments. And so anyway, that's their argument. The farm bureaus in Iowa, Missouri, Nebraska, these neighboring states, they were all in favor of it. So I don't know where they're coming from, but it is bizarre that is where the opposition lies. I will go to the legislature again and make my case. Hopefully the people of Kansas will put a little pressure on their representatives and say, hey, this is, regardless of what position this organization is taking, this is where we stand, and this is an important issue. So, yeah, sorry, long answer to a short question. I talked to the governor at the beginning of the legislative session. We had a meeting, and I talked about some of our legislative priorities, and I mentioned that one, and she didn't voice any objection to it. Hard to say, but I think there's a decent shot that she might sign it. She has signed some things. There were lots of bills relating to crime that she signed. Obviously the hot button issues like the trans issues and the abortion issues, we cannot count on her signature. But I think on that one we might be able to get it.
Attorney General Kris Kobach.
Thank you. Thank you.